Members, Chair lays out as a matter of postponed business. Committee substitute for House Bill 910. We're on floor amendment number 9 by Huff-Hines. Does anyone else have any other questions to speak on the amendment or to ask the author of the amendment any questions?
President.
I know Senator Whitmire has asked to speak. Does anyone else wish to speak?
Mr. President.
Senator Estes.
I was sensing that the body has talked about this long enough, but I might be wrong. I'm just kind of getting the sense of what the body is saying to me here.
I want to be sure that anyone else who wants to speak for or against the amendment has an opportunity.
Thank you.
Senator Menendez, for what purpose?
To a parliamentary inquiry.
State your inquiry.
Are you asking about the Huff-Hines amendment?
Yes. That's where we
Yes.
stopped.
That's where we left off. Yes, I would like to talk.
Okay. Are you asking a question
I am.
to Senator Huff-Hines? Senator Huff-Hines on the floor? Okay, one moment.
Where's Senator Nichols?
Senator Huff-Hines, Senator Menendez has asked if you would yield for a question.
Yes, could I make a quick statement before that? Just a second. Could it?
Yes. Oh, hold on, Senator. Members and everyone outside the rail. We want to be able to hear all senators speak, so I would really ask that we be in order. If you're a House member, you're always welcome here, but please cease the conversations while we go through this debate. We've been on this amendment for about 3 hours. It's an important amendment. It's an important issue. I want to be sure all senators are heard and respected. So, Senator Huff-Hines, you have the floor. You wanted to make a statement before yielding to him.
Yes. Thank you, Mr. President. I appreciate that. And this quick statement, members, earlier in this debate today on this amendment, I represented that CLEAT supports this amendment. And a note was passed to me in the heat of the debate, and that's the note I read to make that statement. And while the Senate was in recess, I had a meeting with CLEAT leadership, and they assured me that CLEAT does not support the amendment, and they, of course, don't support the open carry legislation either. I apologize for this misrepresentation, even though I sincerely, respectfully disagree with their position. But members, this does not affect the merits of my amendment, and I reiterate what my amendment does. And my amendment provides that a peace officer shall not detain a person solely because they're exercising their Second Amendment. Yes, I yield for the question.
Senator Menendez.
Thank you, Mr. President, and thank you, Senator Huff-Hines. I was reading your amendment, and I've read it several times to make sure I wasn't missing anything. And Senator Huff-Hines, I had a conversation when we broke with some law enforcement officers about your amendment, and I asked for scenarios where your amendment could be problematic. And there was a scenario where they asked, well, there are times where law enforcement is called by someone who may be home by themselves and said there's a strange person walking around in front of our house, and they keep going back and forth. And so the question that they had was, if they get a call about a strange person or suspicious behavior, that the person may be carrying a gun, but they haven't broken any laws. So when the police officer arrives, if your amendment goes on, according to what I have read, they can't ask if they have a license to carry. So
no, I appreciate the question,
Sure.
Senator, but that is not what the amendment says. The amendment says the only reason they couldn't be stopped is if the sole reason. And so if they're acting suspicious, they are welcome to be questioned and stopped.
Well, and you know, I did ask that. And so here was the other question that came up. Here's the other concern that some in law enforcement have, because I obviously can't speak for all. The question was, well, what if we stop someone for something else, but then they claim that we stopped them just to ask them whether or not they had a license, and they file some claim or some issue against us for stopping them, and saying that we did it solely because we were looking to see if they had a license to carry. Because, you know, having this amendment is going to cause a serious distinction, a problem, an issue where they're going to not know, you know, they're going to feel, I think, at times that obviously they can't ask that, but was there probable cause or wasn't there probable? It almost feels as if you're creating a source of a claim, potential claim against them.
No, that's not what the amendment does at all. It clearly states that they can't be stopped solely because they're exercising their Second Amendment rights. And they're acting in suspicious behavior, if it's a suspicious circumstances, they're welcome to be questioned. They're welcome to be interrogated for those issues.
Senator Huffines, and I respect your belief, and I believe that you believe exactly what you're saying, and I don't dispute what you're saying, but what I guess the question or the issue, the problem that we're going to have is the definition or the interpretation of the word solely in each and every situation. Because what you're saying is that if that's the only reason that they asked them for their license, then they can't stop them. So then the question comes up when the law enforcement says, no, I stopped you for XYZ, but then I asked you about your license. I mean, I think that having this amendment in the bill becomes problematic for the enforcement of the law. And so I have an amendment that may actually resolve the situation. If your amendment does get on the bill, I have an amendment that would simply require that an image of the license be somewhere on the holster. Then there would be absolutely no reason to ask. It would be visible. Did you know, I don't know if you know this, a detective, law enforcement, may not carry their gun on their hand without their badge somewhere visible? Did you know that?
No, I'm not aware of that.
Yeah. They were informing me that they're not allowed to carry their gun without their badge being somewhere visible. So if it's good enough, or if it's something that we require of law enforcement so that they can detect and tell who they are, why wouldn't we want to do that so that our citizens and our law enforcement officers could know that the person carrying the sidearm on their hip or their shoulder is someone who has met all of the legal requirements that this state requires? Because what the other, the concern is, if we have your amendment, then it becomes free, open game, open season, if you will, pardon the pun, for anyone who wants to carry a gun, knowing that they cannot be asked that they have, if they have a license or not. Anybody can do it. So why even apply for a license?
You know, they'd be breaking the law.
They would be breaking the law, but they wouldn't be able to be asked if they were breaking the law, would they?
No, that's not the case. It's no different, Senator, than if you're driving your car, right? And the police don't have because we have a Constitution. And they don't just pull you over because they want to pull you over. There needs to be a probable cause. And it's no different than that. This amendment should not be this complicated. It should not be controversial. This is a bipartisan issue. We have a Constitution. And this just simply states what's already been codified. It doesn't give any more authority to open carry. It doesn't give any more ability to worm your way around guns, open carry or CHL. It simply states and clarifies what we have in our Constitution.
Senator Huffines, I appreciate and I believe that you believe what you're telling me, but I still feel that there will be times where there's going to be a lack of clarity and it's going to create some consternation. And I think the example that Senator Taylor brought up about when you're having someone come through our security and they don't go through the CHL license, but they come through the metal detector and the gun is there, at that point, your bill says they may not ask solely for the purposes. My interpretation is that they can't ask you if you have a license. You can come in with a gun.
No, that's not correct.
Well, tell me how it's not correct.
Because you're entering in a secure area, and the specific reason for the gun, for the metal detector, is to check for the gun. That's why.
Check for the gun.
And
but
to
they
check
haven't done
to see
anything wrong.
if you have permission to carry the gun. That's
Wait, so you're saying that they'll have to ask if you have permission to carry the gun?
Is that if you have a CHL,
Right.
they'll ask to see the CHL.
But your amendment says they can't.
No, that is, if they have probable cause, for any reason, they have probable cause besides the fact that you're just exercising your Second Amendment.
But I guess, and I'm listening to former judge, our colleague, and lawyer, who's asking me saying to me that walking in the building is not probable cause. They're just walking in.
If you're walking...
So Senator Huffines, you're familiar with the game wardens. Yesterday we had, the whole South Gallery was full of retired game wardens. You're familiar with them, correct?
Yes.
My whole life I've been hunting and fishing since I was 4, and you know that the game warden can come up to you and just ask you for your hunting license, correct? You're aware of that?
If you're surely if you're participating in the hunting activity.
Well, if you're out in the boat, there's no probable cause for that. If you're on a boat in a lake, on a waterway, the game warden can stop your boat and come aboard and check for licenses. And were you aware of that?
If you're participating in the activity that required the license, maybe that's true.
It is, and you have a gun there. And so, see, I just think that while however well-intentioned your amendment may be, it just creates problems, and that's why I have a concern with your amendment going on the bill, but I appreciate your taking my questions. Thank you.
Yes,
Thank you,
certainly,
Mr.
Senator.
President.
Appreciate your questions.
I have no other questions. Senator Whitmire, did you decide to speak or not to speak? Otherwise, I'm going to move passage.
I'd like to speak against the amendment, Mr. President.
All right. You are recognized to speak
In opposition?
on the amendment, in opposition to the amendment.
Yeah, thank you, Mr. President, members. Just a couple of housekeeping matters before I get to the substance. Senator Huffines, I want you to know I would never question your integrity. I know for a fact you thought Cleat had endorsed it, so anyone that's challenged you on your misinformation, it didn't come from my corner. You're an honorable member of this body, and I know someone gave you that information, and you had every right to use it at that time, and you're an honorable man to stand up and correct that bit of testimony. Members, if you'll recall, a few hours ago I stood up and said that I was opposed to the piece of legislation, but I also had reconciled myself to it had the votes to pass, and I would have probably been a quiet no, or certainly made my record clear. But I think it's important, if I could take your time, to go back in time and first establish that I'm not anti-gun. I don't know how many of you know I grew up in Hill County for a major part of my life, 3 miles off a paved road. First gun I fired at 12. You had to really want to fire it because it was a single barrel 12-gauge shotgun that would just about knock a 12-year-old down. So I had to want to hunt and fire that old shotgun really bad. That was the beginning, assuming you don't count the BB guns that I had before that. My house burned down when I was 6, greater in the country. I was in Waco. My father had picked me up on visitation. My family had divorced at 7. My mother remarried, so we went to Hill County, and my father had picked me up for visitation. We went into Waco to a Baylor football game, Senator Birdwell, and we drove up in the driveway, and there was nothing but a chimney left there on Sunday morning. They took us into town, opened the dry goods store, and got me 2 of everything: 2 socks, 2 underwear, 2 shirts, 2 jeans, and we lived in a 1-room shack in Whitney till they could move another house on that piece of property. I tell you all that to let you know my understanding of guns. My 6th grade class of 30 kids in Whitney collected $13 to help us replace my lost goods, and you can guess what I went and bought: a BB gun. And my mother never got over it. So I can sit here and establish my credentials. I was here and voted for Jerry Patterson's CHL. I remember all the scare tactics and the concerns, legitimate, that road rage and shootouts would take place, and you and I know that hasn't been the case. Fast forward, as I said when we debated it originally, up until session 4 last, I got A+ with NRA. They did mailers for me. I don't think guns are necessarily bad if responsible people have them and use them responsibly for sports, protection, Second Amendment. But I did have a difficulty with campus carry because of the incidents around the country, and of course I lost that A+ rating. Fast forward, I am concerned about open carry in general. I'm concerned about this building in particular. I'm concerned about in our communities, not necessarily from the persons that have the license, because they have taken a course, but as someone that's upset or has bad intentions can very easily grab that gun from an open carry person when they're not observing and do serious harm. So if you'd have told me when I was driving to work this morning that I was going to participate as actively in this debate as I am, I'd have said, you're crazy, because it was the last thing I envisioned. But as I said in our question and answer, when your amendment came up, I have a duty to represent my district, the state, and certainly the voices of law enforcement throughout the state, which I have really heard from in the last couple of hours, that I'm going to cite you a couple of their concerns. First of all, their real concern is, Senator Huffines, and I guess you're to be recognized for this, because you had constitutional carry and you pulled it down before we voted. More than one law enforcement, sheriffs have called me this afternoon and said, this is nothing but a backhanded way to accomplish constitutional carry. And I think each and every one of us needs to recognize that, Senator Estes. Senator Estes, I think during the break I heard you say this is a mountain. We're making a mountain out over a molehill. Not in the eyes of the people that have to protect us on a daily basis. And I know the majority of this body was not for constitutional carry, but if we'll slow down and see the real impact of not being able to ask anyone with an open carry firearm, essentially we're at constitutional carry, and it will allow convicted felons, perhaps even a parolee, mentally disturbed individuals to have that firearm without any questions whatsoever. So you won't know if they have a license or not. That was a major point that a Sheriff Association member told me during the break. Also, they pointed out, and I want us all to realize, essentially, for 20 years, concealed weapons have worked, licensed concealed weapons, which allowed officers to ask you if you have a concealed weapon. And I really think this is profound, members, as we take this possible giant step of not allowing law enforcement to ask questions about an open carry, they can do it right now when they pull you over, or if you're approaching this Capitol. Are you carrying a concealed weapon? And the law requires you to say yes and show your license. And you're fixing to do away with that, and it's essentially the same system under open carry that we have under a concealed weapon. And in fact, I had someone that I respect that's in charge of security of this building, and I want you to think about this. We won't need metal detectors. Senator Huffines, we will not need metal detectors in this building if our law enforcement that protect us and the public on a daily basis cannot ask someone if they're coming through the east or any door of this building and they notice a weapon being carried openly, what's the purpose in the metal detectors? So members, I would talk as long as my voice and energy would allow me. I would talk for a week or more. Obviously that's impossible, and I would talk into the evening. I'm not going to talk for the sake of just burning time, because we know a filibuster only works in the closing hours of the session, which we've had a little familiarity with. I've seen it very effectively used in the past for someone, Gonzalo Barrientos, Carlos Truan, a number of members I've served with, on a kind of a regular basis with filibuster a half a day or so to bring attention and focus to an issue. And essentially that's why I'm talking right now. I want the people of Texas, I want all of our constituents to know that in my judgment and in law enforcement's judgment, we're really, really playing with a dangerous matter. It's not something that we can afford to be wrong about. You know, you make a mistake on a lot of legislation, it can be fixed. You make a mistake with this, in the eyes of law enforcement, it's going to cost lives. Now let me speak to a couple of your salient points, Senator Huffines. You say, you can't be asked anything without probable cause. This is not changing anything. Well, you're wrong. I respectfully let you know that criminal justice has exceptions where officers can talk to you, challenge you without probable cause. First and foremost are our game wardens. A game warden can pull you over, approach you in an open field anytime they want to, and ask you for your hunting license, your fishing license, without any probable cause. So there is examples in the penal code and in law enforcement where they do not have to have a probable cause. Likewise for maritime law enforcement. A game warden or a maritime officer, which Austin has on Lake Austin, can drive up and ask you for your safety equipment or your boat license anytime he or she wants to, without any probable cause. So for you to stand there and say that it's just like all other contacts with law enforcement is just wrong. They do not need probable cause to approach you for some of these special issues. Now, I've also heard from law enforcement that can go on and on with issues and examples where they need to be able to ask someone about a weapon, an open carry, certainly in our metropolitan areas. One called and said, if someone is acting in front of a daycare center, no law being broken, but the concern of the parents or the operators, they would need to be able to ask that person, do they have a license for that firearm? And you could probably cite many, many other areas, particularly if you get into some of maybe of our strong religious beliefs, some of the churches that have conflicts with certain groups. Someone could be out in front of a mosque or a tabernacle, not violating the law, but just there with a gun. Law enforcement believes it's necessary to be able to ask those questions. Someone told me earlier today, with all the money y'all are spending on border security, because we are concerned about security along the border, Have any of us stopped to think for a moment what it will be like for law enforcement to go into a fast food establishment along the border that we collectively have already designated as a high-risk area, and see someone sitting there with a pistol and not be able to go ask them, are you a licensed carrier of that firearm, or are you involved in human trafficking, drug trafficking? Are you a member of the cartel? Because they really can't tell by just walking in and observing someone sitting there with a firearm. Talking about just walking in and observing someone reminds me that I need to address the racial profiling concern of some of my colleagues. No one, I will not take a back seat to no one to being against racial profiling. And I would suggest there's been racial profiling before this legislation is passed, or if your amendment goes on. Some of my colleagues that I respect, particularly my African American brothers, I take a back seat to no one. I would do nothing to give anyone the opportunity to profile someone racially, religiously, or any other fashion. Unfortunately, we've had racial profiling since the beginning of time, long before this amendment was presented. Hopefully, Senator West, through your efforts and your colleagues, through dashboard cameras, we have certainly done great strides against racial profiling. And when you're successful with your body cameras, I hope we even reduce racial profiling more. I personally don't think this is going to enhance racial profiling any more than if we did not have it, because if you've got bad police officers, you'll have bad police officers. They don't need this amendment to come up with racial profiling. They can come up with 100 different reasons to pull someone over. I notice no one is using that argument against texting while driving. Now, you talk about some racial profiling. If you're really concerned, you ought to be concerned about racial profiling and who they're going to pull over if they see someone texting. They probably won't pull over someone often that looks like myself. So I could talk, and let me finish on racial profiling. African Americans make up less than 7% of concealed weapon CHL license. One is too many to be profiled. I'd like to say how many Hispanics, to my Hispanic brothers and sisters, colleagues, but how many of y'all know that the DPS considers Hispanics white, Anglo? I don't know why we haven't all got charged up about that, particularly the Tejano or the Hispanic caucus. I wanted to know how many Hispanics have concealed weapon permits, but the DPS historically and still to this day has everyone grouped under the category of white, which doesn't help in this discussion. Let me say one other additional concern, or address your comments, Senator Huffines. I spent 10 years in the House. I respect the House and their right to pass what they choose. I respect Representative Dutton and his views, but I really think there's a distinction between the House and the Senate in that our forefathers really wanted us to have 4-year terms for a reason. And I think I've addressed that with some of the freshmen. We, by design, are supposed to slow legislation down by our 4-year term. We are supposed to not be the immediate reaction that a 2-year House member serves. So, in all due respect, the House has a right to their vote, but it should not be the great influence that you give it. I think I can easily tell you I'm opposed to your amendment. I hope the members will not only vote their district, but vote their conscience. I respect everyone's right to vote their district. Senator Huffines, you know your district better than I do. I really question whether your district would support this, but then you also have a right to vote your convictions, and certainly you're expressing yours today. So let me tell you of my concerns. If I thought the book I've got underneath my desk has got every member of CLEAT, there's 20,000 of them. I got their membership under my desk, and I could read it for the next couple of hours. Then I could go to the Municipal Police Organization and their members. Then I could move over to the Houston Police Officers Union, or I could go up to the Dallas. So I could spend till about midnight letting y'all know how serious I am about this and how I am really honestly fearful for our police officers and consequently fearful for our constituents. But I think I have certainly made myself clear. I have done my job on the Senate floor. I respect the process. I think, as we've all recently in a couple of events talked about, what an honor it is to be a state senator, be one of 31 that represents 26 million. And one of the reasons it's an honor to be a state senator is to have a discussion and a debate such as this. Elections matter. I hope my concerns and fears do not prove correct, because it involves lives. And I will, at this time, Mr. President, tell you that I'm very much opposed to this amendment, and then I'll be opposed to the bill regardless. It is kind of interesting, an observation, that some of my colleagues that are for this amendment plan to do everything they can to kill the bill. So, like I said, everyone has a right to vote their district, vote their conscience, but it's pretty interesting that they're going to put an amendment on a bill that they so badly want to defeat. With that, thank you, members, for your time.
Okay. Members, Senator West, you're next. For what purpose? Your light is on. It's an error. All right. Senator Hall, for what purpose?
I'd like to make a comment and ask the author.
You're recognized. Senator, do you yield?
Yes, I yield for the question.
I wasn't going to say anything at this point, but there have been so many things stated in opposition to this that, by the way they're phrased, have left some less than inaccurate impressions in some people's minds, and I'd just like to give my opinion and clarify some things that were left incomplete, and also address this from another standpoint, because most of the arguments of what I hear reach into the far extreme, much like happens in the arguments on abortion, where they take the far extreme special purpose, less than 0.1% incident, and want to allow abortion for all based on that 0.1%. This bill and all of it is about liberty and freedom. It's about our rights to live in accordance with our Constitution. This is not just about someone strapping on a gun and strutting around to look like a big shot. This allows someone the freedom, if they carry a weapon and they prefer to carry it concealed, they can now ride in their car and hang their coat in the back of the car, and when they get to where they're going, they can get out and put their coat on without being arrested. If they're in a restaurant and it's more comfortable to eat without a coat on, they can take their coat off and enjoy their meal, and then put their coat on when they leave again without being arrested. If they're walking between two buildings here in Austin on an August day and it gets pretty hot out there, they can take their coat off and carry it where they're a little more comfortable and not get arrested because they've exposed their concealed weapon. There's a lot to this bill that goes way beyond just talking about the criminal with the gun, which you have to understand that. And the implication has been, and most of the questions here, is that because of this bill, now anybody can carry a gun, and nothing could be farther from the truth. Under this bill, with or without this amendment, no one can carry a gun, open or concealed, that does not have the license that you currently require, period. And there really is no difference in what that gun can do, whether the person is carrying it concealed or carrying it open. It is still what it is. So that should make no difference at all. But it's about the liberty and freedom for us to be able to do what our founding fathers intended when they very carefully crafted that Constitution and gave us that right. Now, another point I want to clear up that led people to believe that all of a sudden we're going to be unsafe with this building being overrun with people with guns. You can go out there right now and try to get into this building, and it's the same whether you have a concealed or an open carry. You only get in two ways. Either you swipe a card that you're open carry, or let the DPS swipe it for you and you come in, or you go through the metal detector. If you go through the metal detector and set it off, you'll be stopped, and they'll determine why you set it off. If you're carrying a concealed weapon, then you will have to show a license for that, or you will be asked to go out and come in and go around the other side. It's no different with an open carry or concealed carry. So that whole argument has nothing to do with what will happen in this building. It'll be exactly the same. The other issues have been raised on this thing about game wardens, maritime. Those are circumstances that are totally separated and unrelated. It's like comparing apples and oranges. The game warden stops people participating in an event. Maritime is the same thing. They're unrelated. There are other ones, and I could talk about several of them, but I just like to leave it with the fact that this is about giving all of those who choose to carry the right to carry the way they want to carry for their own personal benefit. I'll ask Senator Huffines, is there anything in your amendment that makes the basic bill itself any less effective?
No.
Thank you.
Senator Campbell, for what purpose?
Thank you, Mr. President. To address Senator Huffines.
With a question or?
Regarding this amendment.
All
Yes.
right. You're recognized, Senator Huffines.
I yield for the question.
Thank you. I appreciate the intent of your amendment, and I'm very happy with all the new senators that we have joining us in our body. But as we have heard all day, referred to our Constitution and our founding fathers, and Senator Hall just now said, the United States Constitution carefully crafted by our founding fathers for a specific reason, to make sure it passed and that it was defensible. So, keeping that in mind, the open carry bill brought to us by Senator Estes was carefully crafted. And I would ask if you realize that you adding something to this carefully crafted bill risks taking it out, shooting it down. That's my question.
I don't really believe that's the case. I think that the members here that support open carry will support open carry with or without this amendment.
And I appreciate that, but I'm not really talking about this body. I'm talking about that one over there.
Well, Senator, with all due respect, that body already passed this amendment 130 to 10.
But
133 to 10.
But as we change it,
We're not changing
think
it. This is the exact language that they've already approved.
But as we add, I believe this is we're going to lose this open carry. I'm concerned that we're changing this bill to the detriment of the bill by adding the amendment. And with that, thank you. I don't have anything lengthy.
Thank you, Senator.
Senator Huffman, for what purpose?
Permission to question the author of the amendment?
You're recognized. Do you yield, Senator?
Yes, I yield for the question.
Thank you, Mr. President. Senator Huffines, I'd like to go through just a few legal areas with you. Again, I think Senator Whitmire made an important point that this is a very serious change that makes a major impact, in our opinion, to the state of Texas. And I know that many of the members have made up their minds. I certainly don't expect anyone to change their mind. But I think because this is critical and I believe will have serious implications, I think it's important to our constituents and to the state that we have a healthy discussion and our eyes are wide open about what we're doing. So I'm going to talk to you a little bit about some of the legal issues and ask you some questions about them. What is your definition of reasonable suspicion?
Well, I feel like that the law enforcement will make that call that they do every day, and I'm confident that they'll make the right decision.
Well, certainly you understand that law enforcement has to make that decision every day on the streets, and those have to be determined through objective facts. And later, their decisions will be graded by judges, many levels, at a local level and many times later at appellate level, and certainly all the way up to the Court of Criminal Appeals and even the United States Supreme Court. Just one fact situation. Do you understand that?
Yes.
Okay. So I'm not asking you what a police officer thinks of what reasonable suspicion is. What do you think reasonable suspicion is? You've used the word quite a bit on this floor. I'd like to know what you think it is.
Well, Senator, I appreciate the question, and it's not what I think, it's really what they would think. And the bill really speaks for itself, and it says you cannot solely stop and question and search an individual because they are carrying their
Well, actually, you should know what it is, because by this amendment, you are trying to tell and I don't want Senator West's opinion about reasonable suspicion. I want to know what your opinion is.
I do.
Well, I want to know Senator, I want to know what you think.
Repeat the question, what I think reasonable is?
Reasonable suspicion, and how you think it applies, how a police officer will apply that using your amendment that you're putting onto this bill. And Senator West?
Yes, Senator.
Senator Huffines needs to answer these questions.
I'm trying to. I appreciate the question.
Thank you.
And I said that I am not a policeman. I am not trained to be a policeman. And I am sure with their training and their knowledge that they will make great decisions.
Well,
they do it.
I wish you meant that, Senator Huffines, because they are out on the street and they do have to make those decisions every day about reasonable suspicion. And the courts have given them very specific direction about what reasonable suspicion is. And they have to be able to articulate, if asked, what was the basis of their belief for reasonable suspicion. It's an objective standard. And you are telling them in this amendment that someone with a gun is no longer a factor that they can use solely as an objective standard. And I would submit to you that there are situations where a person, and the sole fact the police officer has is that the person is carrying a weapon, And you are now tying the hands of police officers in specific situations. And it's not going to be in a situation, Senator Hall, where a man is at the Golden Corral with his wife and his children. That's not what we're concerned about, okay? That's not what we're talking about. We're talking about police officers on the streets who are protecting us so that we don't have to go out there and try to protect ourselves. Yes, we have a constitutional right to defend ourselves if called upon, but we live...
Order, please. Quiet.
But we live in an ordered society, and we have to... you're right, the police officers are trained. The courts tell the police that an officer can conduct a lawful temporary detention when they have reasonable suspicion to believe that an individual is violating the law. Reasonable suspicion exists if the officer has specific articulable facts that, when combined with rational inferences from those facts, would lead him to reasonably conclude that a particular person actually or has been or soon to be engaged in criminal activity. Now, there are going to be situations out there where the simple fact that a person is carrying a weapon will cause the officer in his mind, and it's an objective standard, all right, to believe that the person is about to engage in a criminal activity or soon to, or already has recently. But they may not know that the bank has just been robbed, or they may not know. It may be a security officer in a bank, and he sees someone walk in, well-dressed, looks perfectly reasonable, and a customer comes up and says, that man has a gun. Well, under your bill, if the officer had nothing else to articulate about what his suspicions were other than he was in a bank with a gun, then under your bill, the officer could not even you put the words, not even, so we're not talking about arrest here. We're talking about an investigatory stop. An investigatory stop. Again, Senator West, I'm debating Senator Huffines. I'm not debating you.
I'm not saying anything.
Well, I take issue.
Okay, fine, you take issue, I understand.
All right. I didn't know that those were the rules of the Senate. Investigatory stop or a temporary detention. So they can't even temporarily detain, and under legal standards, that could be, if you are limiting a person's ability to move on, then that can be a temporary detention. So even an inquiry by a police officer could be considered a temporary detention. So the language of your bill would prevent police officers from acting even in a situation like that. Again, reasonable suspicion is a standard that has to be met by police officers. They know that. They are trained in that. But they have been trained that a person that they see with a gun, that is reasonable suspicion to them in most instances. And why? Because under current law, under current state law, they would have every right to stop an individual with a gun. Are you familiar with the statutes that are in current state? We'll talk about state law, not federal law. And it's interesting to talk about how this would affect federal law, but that's a whole nother story. But are you familiar with the state statutes that deal with carrying a weapon? That's a question.
Not necessarily. I'm not an attorney, as you know.
Well, I would suggest to you that when you take it upon yourself to take on an issue like this, that you familiarize yourself with the legal penalties associated with these activities. So let's go through the current law as it applies to carrying a weapon in the state of Texas. Sir, I'm sure you know, since you have supported constitutional carry and other bills dealing with guns, that a person commits an offense if he intentionally, knowingly, or recklessly carries on about his or her person a handgun, and it goes on to illegal knife and so forth, but let's just talk about handguns at this time. But certainly no, there are exceptions to that, right? What are the exceptions?
Well, I'm not sure of that.
You don't know? Okay. Well, you can carry a weapon on or about your premises, all right? You can carry a weapon to and from your car to your premises. It's right here in the Law Center, Wes. You want to come look at the statute with me?
Yes. Can I?
Sure, go ahead. You know that you can carry a weapon in your car?
You asked me, do I know if you can carry a weapon in the car? If a CHL, you can, yes.
No, I'm not talking. No, okay, let's back up. Let's back up.
Yes.
We're talking about people who do not have a license. We're talking about people.
Excuse me, Senator. I want quiet in the chamber, please. This is an important issue, important amendment, and the senators deserve respect on the floor. If anyone behind the rail continues to talk, I'm going to ask you to be removed.
We're talking about Senator Hall's citizens who he's talking about, people who have a constitutional right under the Second Amendment to freely exercise their rights as it relates to firearms. Talking about my right. I don't have a CHL license. I can keep guns in my home. When I travel to and from Austin, I can carry my gun from my home to my car, drive with it to Austin, bring it up to my apartment. I have every right to do that. I'm not a CHL holder because the law gives me that right. Do you know what the law is as it relates to carrying a weapon in a vehicle?
Well, I know that you can carry it. With a CHL, it's certainly...
I'm not talking about a CHL holder right now. But this law would apply to a CHL holder, but it applies to every citizen, every one of your constituents, unless they are otherwise prevented from owning a gun because they had convictions or other exemptions.
My amendment does not change at all where you can carry the gun.
Well, I'm about to ask you a question about that.
Okay.
All right. So, under current law, if you have a handgun in a vehicle, you can have it, but you can't have it in plain view. Okay? How does your amendment affect current law? And I've told you what current law is, and that is any person who does not have a CHL license can carry a weapon if they legally have obtained it, of course. I'm talking about legally obtained weapons. You can't carry it in plain view.
Well, my amendment's very simple. If the reason they're getting stopped is solely because they're carrying a gun, that's not a reason to get stopped. And the police have a lot of discretion. They have a lot of experience in determining what would be reasonable.
I'm asking you a question about carrying a weapon in a vehicle. Your bill states that a police officer cannot question or detain or ask questions about the display, the open display of a handgun. Current law states that you cannot carry a handgun in plain view in a vehicle. And I think let's talk about why that's good public policy. What do you think about a police officer, those DPS troopers who are on dark rural roads, or let's say Highway 71 between Austin and Columbus that many of us drive? Do you know how dark and scary that road is at night? I think many people in this room have been on that road at night. I often wonder, wow, we'll see a DPS trooper who's pulled over somebody. I think how scary it must be. I guess they get used to it and they're trained, but I think it would be pretty scary to walk up around those cars. And partly I know that because I've prosecuted cases where police officers have made those calls and ended up with a bullet between their eyes. I've seen the results of that. So I'm sensitive to it for good reason. So now we're telling those officers that these people can carry their gun in plain view in a car on them. And if you walk up to the car because they've been speeding, which you know you can't arrest someone for speeding, I'm sure you know that, unless they have open warrants or something. And you walk up to the car and you see that they have a handgun, is the police officer under your amendment could not inquire as to whether or not they were legally carrying the gun. They would be violating the law if they didn't have a CHL, because if you're a non-CHL holder, you would have to hide the gun. So is the police officer then not allowed to inquire as to whether or not that person is legally entitled to carry that weapon?
Oh, they could inquire about that.
Okay. Well, I'm pretty sure this amendment's going to go on, so while we're at it, let's set up some good legislative intent here. I don't think that's what your bill says, your amendment says, but maybe we can give a break to the police officers here. So it's your belief that a police officer who stops a vehicle for a traffic violation, whatever it may be, and there's of course numerous, it could be speeding, it could be expired license, it could be expired inspection, and they approach the vehicle to inquire about the traffic violation. It's your legislative intent that if they are openly carrying, that it's okay for the police officers in that situation to inquire as to whether or not they have a CHL license. And you know what, I think usually what police do when they see a gun like that, I think they pretty much tell you to get out the car with your hands up and, you know, lie flat on the ground is probably what they do, because they have to be proactive in those situations. That would certainly go beyond a temporary detention or an investigatory stop. And it would be more of a full detainment in that situation. They may ultimately let them go, but so you're not, you don't feel like a situation like that would be affected by your bill?
No, I do not think that.
Okay, why don't you explain that to me, because I'm curious, because I'd like to know how you come through that thought process to that conclusion, because it really doesn't make a lot of sense based on other things that you've said here on the floor as we debated this bill. So explain to me how that is different than approaching, you know, someone who is, you know, at a bank or something along those lines.
Well, my bill doesn't change the CHL process at all. So if they're pulling someone over, they need to display the CHL license just like they're currently doing. And if they don't, if they have a gun, let's say visible in the car, then they don't have a CHL, they're breaking the law.
So you think it's so it would be okay under your scenario for the police officer to ask in that question if they had a CHL license?
Yes, that is correct. If they're breaking the law when they got pulled over, they have a right to ask if they're carrying and to disarm the individual, to take whatever reasonable precautions they need to take.
Okay. Let's talk a little bit about I think there's been some discussion, I know Senator Nichols went through with you this afternoon about his belief, and by many on the floor, that this is just kind of a backdoor to constitutional carry because of the fact that it really, any person would feel that they could just carry a gun without a license because they know the police can inquire of them if they have a license, because that's what your amendment does. So I think the public policy in the public policy concern about this is that many people, I believe, will do this, and it makes it impossible for police to enforce the licensing of CHL holders as they've done successfully and very amicably with CHL license holders for over 20 years. And I continue to hear from police officers who say to us, this has not been a problem. And I haven't heard any CHL license holders tell me that they feel like they've been abused by police or so forth. But I do believe, and you continue to say, and others who have debated this continue to say, that the objective is to protect the law-abiding CHL holder who is simply exercising his or her Second Amendment rights. These are the people that we want to protect, and these are the people that deserve this right. But I think we can all agree that that's an admirable cause, but one of the side effects of doing that is that we are going to have people who cannot qualify for CHLs. We are going to have felons. We are going to have individuals who perhaps have unfortunate mental impairments that would otherwise prevent them from getting a CHL license. We are going to have issues with individuals like that openly carrying without the police being able to investigate that. So with that in mind, I would like to propose something to you, a thought that I perhaps would have about an amendment. Are you familiar now with the current punishment scheme for individuals who unlawfully carry a weapon? Those would be people who don't have a CHL license, who are not carrying on their premises or to and from their premises or legally in a vehicle. Are you familiar with the current punishment scheme under the Texas Penal Code?
Remind me of that, please.
Well, okay. It's a Class A misdemeanor, okay? And unless it's in a premise that sells alcohol, a bar, and then it becomes
Felony.
A third-degree felony. Let me check my fact. I believe that's correct. That's a third-degree felony. Third-degree felony is punishable by 2 to 10 years in prison. Okay, and we've done that. We made that a felony because clearly it was the intention of the legislature that they don't want people to carry a gun in a bar, and that makes sense. I mean, and we create, the way we set up punishment schemes is we make punishment more severe as we more and more want to deter the behavior. Would you agree with me that it would be important to deter individuals who did not have a valid CHL license, or those who would choose to violate the law, to be heavily deterred from committing this offense? Because clearly, if you get a bunch of folks out there who have bad intentions when it comes to carrying a weapon, I think eventually the good people of this state, the good CHL holders, are going to be punished for that. Would you agree that eventually there's going to be public backlash, public push against this whole notion if we start having folks that really shouldn't be openly carrying weapons? Would you agree with that? That we want to deter that behavior?
No, I don't agree with the first premise, which was this would turn people against open carry.
So what my proposal is, I think that we should raise the punishment. If we're going to say now we're going to let licensed people carry weapons openly, and we're not going to let the police stop and make sure that they are one of the good guys, no matter how temporary. My submission would be then what we should do is make sure that we have a really strict penalty for those who are violating the law. And why? Because the stronger the punishment, the more the deterrence, and that would help to deter those folks from unlawfully carrying a weapon. Does that make sense to you?
I understand your premise, yes.
Yes. So how would you feel about an amendment if I offered up an amendment that said we're now going to raise the punishment for carrying a weapon that's the same as it would be now for in liquor establishments, that is a third-degree felony. So now, if you carried a weapon, of course, it would be outside of the constitutional protected, outside of what the state has protected through statute of your home, going to and from your home, traveling, not in plain view, but otherwise just out on the street, in the supermarket, in the bank, wherever it may be, but you don't have a license. What if we raise that to the same as if it was in a bar, to a third-degree felony? Make all those felonies. Or we could go higher. We could make it a second degree. We could do 20 years in prison. Or we could even go to a first degree. 5 to life.
Well, I don't think that is not... I understand what your thoughts are on it, Senator, I do. But
I'm just trying to protect the public, so I'm reaching for ideas here to keep, to tell the bad guys, not our good folks.
It's already against the law, and they already will go to jail, and they will have their day in court, and right now go ahead.
Okay, you just said something. You said right now it's against the law and they will have their day in court. But you see, the problem is that it's difficult now for the police officers to do their job, to find the bad guys who have the guns, to find those unfortunate who have some mental problems that prevent them from having a gun. To talk to the just released felon who was stopped at the corner drug dealer and picked up a .357 and a crack rock or whatever, or some meth, because the police officers don't have that option. You are tying the hands of law enforcement. So again, what would you feel about raising the penalty?
Well, Senator, the issue that we're talking about here is really that, first I'm going to disagree with your premise. They can stop somebody that looks suspicious, and but they can't just stop them because they're carrying the weapon. I mean, right now you can carry a long gun, right?
Yes.
Can you carry a long gun? You could carry a AK-47, walk down the street, right? And you don't have to have a permit for that. You don't have to, that's not a reason to be stopped. It's perfectly legal to carry a shotgun and walk down the street. There's no permit necessary.
Senator West, your microphone's over here.
Yeah, I'll step up here. Right there. But so I understand your premise, but we're talking about here, and what this amendment's about is about exercising the Second Amendment right and exercising the right that you have when you have a CHL license.
And no one is trying to infringe upon anybody's Second Amendment right. No, we're giving them the right in this legislation to openly carry in the state of Texas. No one is infringing upon that right. But the law and the Constitution gives the state authority to regulate this within reasonable means for the safety and security of the citizens of this state and the United States of America. And Texas has always protected Second Amendment rights of individuals, and I'd say Texas is a free state that loves liberty and has a reputation around the world of being a free, independent-minded, strong, I've got people yelling comments here, but strong beliefs in individual rights. But with certain rights come responsibilities, and there has to be some social order. It's just part of the world that we live in. Senator Whitmire and I live in large metropolitan cities. There's many of you, Senator Rusty, San Antonio, Senator Hidalgo. What did I say?
Kind of big.
Oh yeah, Senator Hidosa.
It's getting bigger.
What I called. Senator Ellis, your HPD officers are listening. Senator Garcia, you all live in cities, and we have to have order. Senator West, you know what I'm talking about. I know you know what I'm talking about.
I know what you're talking about.
I know you do. And my point is that you can have rights, but with rights comes some responsibility. And for the life of me, I do not believe that the vast majority of CHL holders in this great state would feel that they were being violated or infringed upon if a police officer politely said, "Sir, ma'am, do you have a CHL license?" They've been doing that for years. It's not going to happen in every situation. It's not. You know that. Everyone in here knows that. I used the example today, Senator Seliger's, he has half of West Texas in his Senate district or more. And, you know, what Joe Bob in the diner and the sheriff knows him with his open gun, he's not going to get stopped. No one's going to ask him anything. But maybe in Senator Ellis's, some of his areas that he represents, some of the areas I represent in a city, with police officers who are valiantly trying to do their job, that there are going to be instances when it's in the public's best interest, my constituents' best interest, for them to be able to politely ask someone who is standing there with a gun if they are lawfully, if they have a license. I do not find that offensive, and I submit to you, Senator Huff-Hines, that the vast majority of people who live in this state will not find that offensive. I support Second Amendment rights as much as anyone in this room. I have many guns. My father was a Marine. He joined the Marines when he was 17 years old. The first song I knew was the Marine hymn. Did you know that, Senator Uresti? I was raised with guns. I was raised hunting. I believe in it, but I believe in some social order too, and I believe in supporting our law enforcement. And I understand the votes are here, but I'm not sitting down until I have made my point that this is a mistake. And I think it's a mistake that the state of Texas will come to regret. I know I can't win this fight, but I'm going to stand up and fight it because it's a fight worth fighting for. And you are just plain wrong on this. And I understand it's an unfortunate mix of a coalition here where you have folks doing things for different reasons, and that's fine. Everyone in here has a right to vote their conscience, and I, as much as anyone, respect that. And I respect what's going to happen, but it's not, that does not make it right. Thank you, members, for having me, let me have the opportunity to say what I think, what I know to be the truth. And I ask each one of you to examine your conscience and think about your constituents and what they would want you to do. Thank you. Thank you, Mr. President and members.
Thank you, Senator.
Senator Taylor from Collin County. Where's Senator Taylor? His light is on. Take your time, Senator. We're going to be here a while. We have 30 bills or more after this one.
Thank you, Mr. President.
You're recognized for what purpose?
Just wanted to talk with the author for a second.
You have the floor. Do you have a question for the author?
I was hoping the author of the amendment would yield for
Will you
some
yield?
questions.
I yield the floor for a moment.
Thank you, Mr. President. Senator Huffines, I just wanted to make sure that, again, we're clear about this. I think what we're talking about here with your amendment is making sure that current federal law, so I had an exchange earlier with Senator Estes, and I asked him whether or not police officers can stop somebody from doing something that requires a license. And the examples I used were driving a car, riding a motorcycle, and driving a commercial vehicle that you need a commercial driver's license for. And he affirmed that it's very, very clear case law on the federal side that our Fourth Amendment of the U.S. Constitution protects us from being stopped by police officers if we are licensed, if they want to verify that we are doing something that requires a license. So they can't stop us. And so what I think your amendment is doing is it's clarifying into state statute what is already existing law by case law that's been upheld in several, I believe it's in 2 different appeals courts where police officers have stopped individuals who were openly carrying and asked them for a license, and they couldn't do that. Now, I think one example was that went all the way up to the Fifth Circuit, actually up to a Court of Appeals, where the individual was arrested. Does this sound familiar to you?
Yes.
And so, again, I think what we're doing, what you're doing here, is you're taking what's existing federal law, and I think my conversation with Senator Estes was very clear that police officers can't stop someone who's doing something that requires a license, even if they do require a license, to verify that they have a license. And so I think that, to me, your amendment makes sense because you're putting in statute what is already existing. And what I'm concerned about is it seems to be the people that are opposing your amendment seem to think that police officers have the right to stop anyone they choose to see if they have a license to do whatever it is that they're doing. And again, the conversation I had with Senator Estes was that's clearly not the case. That is not the law of the land. The law of the land is they cannot stop someone. And so I think that what you're trying to do with this amendment is protect police officers from making a mistake. And the mistake would be to start interrogating someone, do you have a license, when they're not legally allowed to do that. So I look at your amendment as guiding law enforcement to not make a mistake. And then in turn, that I think protects not only the citizen, but it also protects law enforcement. When this amendment first went on in the House, there was concern by my own police department. And we had some conversations with them. We sent them the cases, the case law, and they read that and they said, you know what, we think that we're okay with this. They actually withdrew, they went from opposed to neutral, back home, the Plano Police Department, because they understood that they could not stop someone. They know that they've got to have probable cause to stop someone. And probable cause is not seeing someone doing something that requires a license. They have to think that there's some crime, perhaps may have. And so, I think you're protecting not only the citizens, but I think you're protecting law enforcement. Do you want to speak to that? Or?
Well, thank you for the comment, Senator. This absolutely protects law enforcement. It protects the taxpayers from the inevitable lawsuits that are going to come without this amendment being attached.
All right. I think what you're doing makes sense, and it makes sense for the people who are going to use their CHL to open carry in this state, and I think it makes sense for law enforcement because of the way the law of the land is in Texas and in America already. So what I think is interesting to me is whether or not your amendment goes on, CHL holders who choose to open carry, should this bill become law, would be protected from being stopped by police officers who wanted to ask questions, unless there was probable cause. But again, I think you're protecting the citizens that we've been sent here to serve, and the law enforcement personnel who are also enforcing the laws of this great state. Mr. President, thank you very much.
Thank you. Senator, I don't have any more speakers, but I understand there may be an amendment coming, so I'm going to make sure that there is not, or there is, and I'll hold.
No.
Senator Estes, to be clear, if I was waiting for an amendment, we'd vote on this right now. I believe there's an amendment to the amendment, but I'm waiting. I don't see the senator on the floor, so.
Question.
Yes.
The amendment that Senator Huffman talked about, is that an amendment to the amendment or just another amendment to be debated?
I'm not advised,
Okay.
but I understand it may be an amendment to the amendment.
Thank you.
Here she goes. Senator Huffman, we are ready to vote, and you said you may have an amendment to the amendment. If you do, we
Yes,
need it.
Mr. President, if I could be recognized, I do. If I could just ask your indulgence just for a brief time, I just need to review it quickly and make copies. But
5 minutes or
that would be
10
very helpful.
5 minutes?
If you'd be willing to do that. Thank you. I
All right.
appreciate it.
We will stand at ease for 5 minutes for her to make the copies. Members, I'm advised they're making copies, so it should just be a minute or two. Members, Senate comes to order. Members, there is an amendment to the amendment. The amendment to the amendment will be passed out. This would be amendment number 10, amending number 9. And if anyone else is planning an amendment, please get it in, for or against, because we're moving. Senator Huffman, you are recognized on your amendment to the amendment.
Thank you, Mr. President and members. Members, during the debate that we've had this evening, Senator Huffines and I engaged in a discussion about my belief that his amendment would create an incentive for those who could not otherwise legally carry a handgun and legally enjoy their Second Amendment right. My belief that that will cause some to open carry or to recklessly carry handguns when they do not have the training and the licensing to do so under Texas law. So we discussed how it was important to create a deterrent to that type of behavior. So members, this amendment to the amendment does not touch Senator Huffines' language and his intent. All it does is enhances the penalty of under current law for recklessly, intentionally, or knowingly carrying on or about your person a handgun. It doesn't affect the penalty range for other illegal weapons like knives or clubs or brass knuckles. It simply states that if you intentionally, knowingly, or recklessly carry a handgun, which I think his amendment will encourage people to do, that the punishment range will be a second-degree felony, which means it would be punishable by 2 to 20 years in prison. Again, a judge or jury would have the full range of punishment, and in an appropriate circumstance, a jury could consider probation, a judge could consider probation as well. Again, I think this will send a strong message that we will deter individuals from carrying a weapon unless they have a CHL license. So I move adoption of the amendment, which would be Amendment 10, to adopt Amendment 9 by Senator Huffines.
Okay. Senator West on the amendment to the amendment.
Question of the author of the amendment.
Do you yield?
Yes, sir.
Senator Huffman, what is the penalty range for a second-degree felony?
2 to 20 years in prison.
What's the fine?
I believe it's $10,000, fine up to $10,000.
Yeah, 10 I think it may be up to 20.
Could it be 20?
It could
It's
be 20.
10 to it's 10 or 20.
So
I'd have to refer.
Right now, unlawfully carrying a weapon is a Class A misdemeanor?
That's correct.
And what is the penalty range for a Class A misdemeanor?
It's up to a year in the county jail and
I think it's a $4,000
$4,000 fine?
Yeah, I think it's 4 now.
it's 2 to 4, I think.
Yeah. Okay, so for purposes of illustration, would you tell the members of the, I was going to say jury, but the members of the Senate,
Sure.
What are some other second-degree offenses?
Oh,
well, let me back up. Could you just kind of go through the different levels of offenses? Capital murder, right?
Right. Death penalty or life without parole.
First-degree felony is what?
5 to 99 or life.
Right.
And again, the fine, I think it's up to 20, 10, 20.
Somewhere up in there,
It's
right.
somewhere in there. Nobody ever gets fined.
And
a
then
full
we have
amount.
second-degree offenses,
2 to 20,
and then third-degree offenses,
2 to 10,
and then Class A, Class B, and Class C, right?
and state jail.
All right, state jail, that's
Yeah.
right. And
6
so,
months to 2 years.
over the years of Senator Whitmire's guidance as the, where is he anyway? Disappeared on me. All right. His guidance as the chair of criminal justice, we have decided on issues concerning enhancements and increasing penalties and things of that nature. Is that correct?
Yes.
Okay, so right now, the legislative body has decided up to this point in time in history that it should be a Class A offense to unlawfully carry a weapon.
Yes, I believe it's been that for some time,
And it has been for some time. I
other
think-
than carrying in a liquor license establishment.
Exactly, and I think
Yes.
it's been that way, and I was going to ask Senator Whitmire, I think it's been that way since like 1970 something.
I believe that's correct.
Okay, I think 73. And so you want to make it a second-degree felony now?
Yes.
And so that the members will know exactly what a second-degree felony is, can you tell them some of the other offenses we consider second-degree felonies?
Well, I believe that robbery is a second-degree felony.
Robbery.
I believe drug possession of
A certain
over
amount.
400 grams. I don't
Right.
know exactly
Right.
because it's,
Right.
a complicated penalty range, large amount of marijuana. I believe that there are some aggravated assaults that are more than, threats. So there's some aggravated assaults that rise to that level. Those are the ones that come to
Okay,
my mind.
off the top of your
but-
head, and
Yes, yeah.
that's fair.
Yeah.
And so you believe that unlawfully carrying a weapon is equal to a robbery?
I believe that at the time that these statutes were enacted, that we didn't have the situation that is being created by the amendment to this legislation.
Is it the amendment or the bill?
I think it's the amendment to the legislation because I'm not trying to deter behavior of the good law-abiding citizens who have CHL licenses. I'm trying to deter the behavior of criminals who are going to take advantage of this loophole in the law and prevent and create dangerous situations in our society.
So you
I believe if we have a strong enough deterrent effect that maybe it will deter criminals. Understand a CHL holder will never get this punishment. This will only be for lawbreakers, not for CHL holders.
And so what you're saying then, if a person doesn't have a CHL, they are potentially a lawbreaker, right? So if a single woman doesn't have a CHL but has a handgun, we're talking about handguns, right?
Only handguns.
Okay, we're not talking about rifles. We're not talking about AK-47s.
No.
We're talking about a handgun.
Right.
All right, so if a single head of household, be it male or female, has a gun, and they are caught with it in an inappropriate place, if this amendment goes on to the amendment, that person would be exposed to 2 to 20 years.
If they intentionally, knowingly, or recklessly.
Intentionally? Their conscious objective to engage in behavior and cause the result.
Right.
Knowingly, they may be consciously aware
Right.
of it. Recklessly, they're just reckless.
Well,
They could get, under your amendment, 2 to 20 years.
yes.
And you think that that is what the criminal justice scheme of punishment that it was meant for? To put someone with a Class A misdemeanor since 1973, and you do agree that we've looked at punishment ranges several times
Yes.
since 73, and
Yes.
have always left that
Yes.
at a Class A misdemeanor.
Right.
And so you believe that under these facts and circumstances, a single parent that inappropriately carries a gun that's not a CHL should be exposed to a second-degree felony, punishable by 2 to 20 years in the penitentiary.
I think that a single parent, and I don't know this mythical single parent.
Yeah, we've been talking about mythical things all day.
Well, some of them seem pretty like a hard taste of reality to me, but I think that a judge will use discretion like they always do. As I said, there are probated sentences allowed, and there's 20 years in prison allowed. I think that as we have set up these punishment schemes over the years with a lot of thought, as you said, we did not have facing us the situation that we do tonight in Texas. And I believe that this will be a deterrent for illegal behavior associated with openly carrying weapons. Again, and I stress this, this will not affect a law-abiding citizen, will not affect a CHL holder.
And how do you define law-abiding citizen?
Maybe we'll encourage many people to go out and get their CHL license, which I think would be a great thing.
If a person doesn't have a CHL, they're not law-abiding? I don't have
Of course they're law-abiding, and they can
That's exactly the point.
They can carry their gun in their house, they can carry their gun in their car, they can carry their gun to and from their car, they can carry their gun in a boat, they can carry their gun if they're transporting large sums of money.
I'm talking about, ma'am.
Lots of exceptions.
That's what I said. That's what I'm saying in terms of, and I'm not going to rehash that with you, but if they make a mistake and they have a gun with them and they're stopped and they're arrested, you want them to be exposed to a second-degree felony punishable by from 2 years to 20 years in the penitentiary. And you talk about probation. Probation is a conviction, isn't it?
Doesn't what?
It is a conviction.
It can't,
Probation.
Probation is a conviction.
Right.
Mhm.
Okay, and so a person get a conviction, they're placed on probation. Let's say it's first offense, and this goes on. First offense. They get a conviction, and you know what a conviction carries with it, right?
Sure.
Okay, and that's what you want to do based on something that's right now a Class A misdemeanor. Now, let me say this to you also, and I wish Senator Whitmire would come back out here. He's probably back in the back. I do believe that since we have put CHLs in, we've also looked at penalties again to make a determination as to whether or not carrying a firearm, an illegal weapon, whether the punishment should be up to a state jail felony. I think that's what we did. I could be wrong. He can answer that question. Or a third-degree felony. And we decided against that. The legislative body decided against that. I think the Senate decided against it.
Yes.
Okay, and so let me ask this. If Senator Huffine's amendment didn't go on, would you
did not?
Did not go on.
Yes.
Would you still offer this amendment?
No.
Thank you very much.
Thank you.
Senator Ellis, for what purpose?
To ask Senator Huffman a few questions.
Senator Huffman? Do you yield?
Sorry. Yes, I yield. I'm sorry. Someone was talking.
Senator, why wouldn't you offer this as a separate standalone amendment by itself if your intent is actually to get it as part of the bill? Why wouldn't you offer it as a standalone amendment as opposed to an amendment to Senator Huffine's amendment?
Because my intention is to only get it on as an amendment. It really truly is an amendment to his amendment, because I only think it's necessary for a very strong deterrent statement if his amendment goes on. I would never, I think Senator West just asked me that question, I would never have stood up in this debate and offered this amendment to Senator Estes' legislation. I think Senator Estes had a good piece of legislation. I wouldn't have offered it. My intent in offering it is because I feel so strongly that we need to have a deterrent effect for those who take advantage of those who would choose to break the law and take advantage of Senator Huffine's amendment. So that's why. I don't know if that answers your question, but that's the honest.
Somewhat, Senator, as you know, the clock is ticking on this issue, and Senator Huffine's amendment passed the House by an overwhelming margin.
Yes, we've heard that.
Is it fair to say that you're putting, if this amendment were to go on, it would force a conference committee and could very well kill this bill?
I don't think a conference committee should necessarily kill a bill. We have conference committees on many pieces of legislation that has passed through both houses. In fact, I don't even know what the percentage is, but I would say it's a high percentage of this time of session that we have conference committees, and most of them are amicably resolved in some way, shape, or form.
Well, obviously, you know from discussion earlier, I would prefer not to have Senator Estes' bill.
Yes.
So if you were to do something that triggers putting this in a conference committee and it comes back late enough, you do think that I have the ability to talk for a long time, right?
I know you can talk.
So wouldn't that be a
And very
concern
well.
of yours if this amendment were to be added to his amendment? It goes to the House, it takes them a while to get to it, it comes back, conference committee, when it comes back over here, I can talk a long time. I know I'm normally brief with my comments, but I could really go on a pretty good amount of time. Is that a concern that you would have?
Not at this point in the procedure. If we were a few days down the road, maybe. I think we're in good shape. We have just started this process of conferencing. I think the calendar is very safe. It's not my intention to kill this bill, Senator Ellis. Not in the least. It's not my intention.
Well,
and I know you can talk, and I know you're
Obviously,
talk
no.
for a long time, but you can't talk that long.
You know I'm not concerned about my NRA rating. It's too late.
Right.
That's not really a concern for me. But is it fair to say for members who are concerned about that NRA rating, if this were to be added and somehow this bill comes back in a time frame in which I could talk it to death, they're going to get credit, and it's going to hurt them with their NRA rating if that happens?
Well, I hope that we're not making votes worried about our NRA rating, but doing what we think is right and constitutionally the best thing to do. And I think my
Well, in that
NRA
case, I hope
friends
he'll
may
pull
be
the bill
watching,
down.
and I feel confident that they know that I'm doing this for the right reasons.
Do you think
And
the House will accept it?
I don't know. I don't know what to think of what the the House will accept or not. There may be people in the House who like this.
Good luck.
Maybe, well, I don't know. Well, I think it's going to take more than luck, Senator Ellis.
Thank you.
Thank you for wishing me well.
Thank you very much.
Thank you.
Senator Huffines, you're recognized on the amendment to the amendment.
Thank you, Mr. President. I have a parliamentary inquiry.
Please state your inquiry. State your inquiry.
Yes. My parliamentary inquiry is germaneness.
Please bring your inquiry forward.
Thank you.
Senator Huffines, I'm going to acknowledge you made a parliamentary inquiry. Senator Huffman, do you
Yes,
wish to pull it down?
I must pull down my amendment to the amendment. Thank you very much,
All right.
Mr. President, members.
Thank you, Senator.
When you get to the amendments, you ought to ask the husband if she's going to vote for the bill if the amendment goes on.
Okay. Mr. President?
Senator Huffines?
Yes.
Can we have order?
I'd like to move for adoption of my amendment.
Senator Taylor of Collin, who I think supports your amendment, you want to speak?
Yes, Mr. President, I needed to ask the author. I realize I've already spoken on this amendment, but
So has everyone else.
First I wanted to say I referenced the Plano Police Department, and I made a mistake. They are opposed to this amendment and this bill. I spent about a quarter of an hour with their attorney, and he raised a very important legal constitutional question that I need to have clarified here on the floor.
Remember, just want to be sure everybody can hear. Okay,
Thank you,
go
Mr.
ahead.
President. So there are three kinds of stops that a police officer can conduct. One is a consensual stop, the second is an investigative stop, and the third is an arrest. And so this amendment, as I read it, Senator Huffines, is stopping, quote, certain investigatory stops and inquiries, correct?
Yes.
Right, that's the title of your amendment. And so I wanted to be sure that we clarify, you and I, that this amendment allows consensual stops to continue, but in fact prohibits investigative stops for merely wearing a firearm openly.
That is correct.
Okay, so I'm going to say this one more time because I'm going to ask it to be put in the journal because I think this is really important because at least my police department is concerned that there's just a skosh of ambiguity. It's not ambiguous to me, and I don't think it's ambiguous to you, but just as they read the language, they're concerned that this amendment may stop consensual stops. But it is my understanding this amendment does not stop a police officer from making a consensual stop. Is that your understanding?
That's my understanding.
Okay. Mr. President, if I may, if I could have the last two exchanges between myself and Senator Huffines about consensual stops recorded in the journal and then read in the record so that police departments across Texas know that they can still do consensual stops even if this amendment goes on the bill and becomes law in the state of Texas.
Members, is there any objection? One moment, Senator Taylor. Senator Whitmire, for what purpose?
I'd like to ask the gentleman a question.
You recognize, do you yield, Senator Taylor?
Of course.
The controversy is not whether they can do a consensual stop, it's what the officer can ask and inquire about once he pulls them over.
I'm sorry, Senator.
We're not spending hours talking about whether an officer agrees with consensual. Oh, I'm sorry. The issue or controversy is not about the stopping, it's the inquiry about do you have a license to carry that pistol? And you're not helping your Plano police officers who are strongly opposed to this by clearing up the procedure to stop someone. The controversy or the matter before us is the inquiry when they pull you over on a consensual stop if you've got a pistol on your side.
Right, and I think what a consensual stops consists of, and again, I've just gotten a lesson on this, what a consensual stop consists of, a police officer can walk up to any individual and say, you know, how are you, Mr. Whitmire?
That's a detention. You know, Huffines can have his attorney. I've got mine.
Mr. President.
That's
Mr. President.
Senator Huffines.
Thank you, Mr. President. I do have a motion on the floor. I move for adoption of my amendment.
You yielded to Senator Taylor to ask you
For a question.
He made a motion to put your dialogue in the journal. Senator Whitmire stood for the purpose of asking Senator Taylor a question, and he yielded the floor to Senator Whitmire.
So
Senator Taylor has the floor, Senator Huffines, right now, and he has a motion.
Yeah, if
I
we,
yield.
Okay,
if
so
we-
now the motion on the floor is to put the conversation, you said both conversations?
well, the conversation regarding regarding the consensual stops. So not the entire discussion that he and I have, but the discussion regarding consensual stops.
Is there any objection? Senator Huffman.
Yes, but before I vote to have that recorded, I want to make sure we are recording something that has any value or worth to future courts to look at. And I don't believe what is in the record is very helpful, because there was some discussion about what's in the caption or the title of the section, but I wonder what is the difference in your mind. I don't know if it's important what's in your mind, Senator Taylor or Senator Huffines, between a consensual stop, an investigatory, I'm just reading the language of this, an investigatory stop, or other temporary detention. Because if this is going to be what police officers in the courts, all the way up to the United States Supreme Court, have to use to determine what the legislative intent is, I think we need a lot more substantive debate about what those three things mean and what your legislative intent is. Because a consensual stop is very close to a temporary detention. In fact, it's almost impossible to approach an individual without it being a temporary detention. You didn't say a detention and you say no stop. So let's make sure that the police officers have guidance about what they can and cannot do.
I withdraw my motion, Mr. President.
Okay, the motion is withdrawn. Members, we are on floor amendment number 9. Senator, the question is on adoption. Senator Estes, you finally, after 6 hours, get to say something on the amendment.
Thank you, Mr. President. Members, we've had a long debate. This issue has been examined from every side that I can think of. I will leave this to the will of the body. I will be voting no. Members, vote your own conscience.
The Secretary will call the roll.
Bettencourt.
One moment, so be very clear. You're voting, this is not tabling, this is on the adoption. You're either voting of Senator Huffines' amendment. You're voting for or against his amendment. 1 or 2. Yes or no. It's not a table, it's on the amendment.
Burton, Campbell, Creighton, Ellis, Eltime, Estes, Frazier, Garcia, Hall, Hancock, Hinojosa, Huffines, Huffman, Colcourse, Lucio, Menendez, Nelson, Nichols, Perry, Rodriguez, Schwertner, Seliger. Taylor of Galveston.
No.
Taylor of Collin. Uresti, Watson, West, Whitmire, Saffarini.
There being 19 ayes and 12 nays, the amendment is adopted. Members, we have an amendment. This is Amendment 11 by Watson.
Floor Amendment number 11 by Watson.
Senator Watson, please explain your amendment.
Thank you very much, Mr. President. Members, I know it's been a long and difficult day, but please give me your attention on this amendment because it fills a hole that we need to fill in this bill. In the bill, there's a section that the body has already voted on previously and was voted on in the House. And what the section does, and if you have a copy of the bill, it begins on line 13-70, and it's the section that says a license holder commits an offense if they carry a gun concealed or carried in a shoulder or belt holster, and then it lists a number of places you can't carry it. For example, a place where alcoholic beverages are served, high school, collegiate, or professional sporting event, premises of a correctional facility, and then in number 4, what it says is on the premises of a hospital licensed under Chapter 241 of the Health and Safety Code. Chapter 241 of the Health and Safety Code. Chapter 241 provides the definition of a general hospital and a special hospital, and I won't go into all of those details, but what it fails to include, and there would be a gap here, would be mental health facilities or a mental hospital. Under Chapter 571, you find the definition of mental hospital. So what this amendment does is it plugs that hole. We've already got an exception for hospitals under 241, but the bill leaves out mental hospitals. So this amendment would add mental hospitals to the same provision of law dealing with guns in general hospitals. Mr. President, I move adoption.
Senator Huffines, you're recognized on Senator Watson's amendment. I'm sorry, Senator Estes. I've been talking to you so long today, Senator Huffines. I thought it was your bill. Forgive me. Senator Estes, you're recognized on the amendment.
Thank you, Mr. President. Senator Watson, I actually think that, like I told Senator Rodriguez earlier, I think that this possibly could be a standalone bill in our next session and be studied this interim. It is my goal to neither increase nor decrease any place a gun can be carried, so respectfully I move to table.
Members, to close, Senator Watson.
I think we've had enough debate. I just say one thing. If we're going to recognize, if the legislature is going to recognize that there should be an exception of where you can carry and open carry as it applies to general hospitals, we ought to go ahead and make sure we've got it clear, and it would also apply and not create a gap in our law, our law for mental hospitals.
Senator West, for what purpose?
Well, Senator Watson, you?
Do you yield? Senator Watson?
Senator,
Sure.
you agree that if a facility does not want to have any handguns on their premises, they can put up a sign right now. You agree with that, right?
I agree with that, but Senator West, we've written into law certain places where that you can do that and be in compliance with the law. This law also says that if somebody takes it into one of those places, it describes, as you discussed with Senator Huffman, what the criminal offense is. And what's happened is we're getting ready to pass a bill out of here that limits it to just general hospitals and in some instances special hospitals, but it does not include mental hospitals because that's in a different section of code.
All right, thank you.
Okay, members, the motion on the floor is to table. Senator Estes, you moved to table, correct?
Table.
The motion on the floor is to table.
Move to table.
The amendment by Senator Watson. The Secretary will call the roll.
Bettencourt, Birdwell, Burton, Campbell, Creighton, Ellis, Eltive, Estes, Frazier, Garcia, Hall, Hancock, Hinojosa, Huffines, Huffman, Colcourse, Lucio, Menendez, Nelson, Nichols, Perry, Rodriguez, Schwertner, Sulliger, Taylor of Galveston, Taylor of Collin, Uresti, Watson, West, Whitmire, Zaffarini.
Members, I'm sorry. Oh, you had one you missed. I'm sorry. There being 25 ayes and 6 nays, the motion to table prevails. Members, there is an amendment. I'll wait till it gets to the back row before we read it. Secretary will read the amendment.
Floor amendment number 12 by Huffman.
Senator Huffman, you're recognized on your amendment.
Thank you, Mr. President. Members, again, I won't belabor the debate or the argument, only to state, again, my intention is to create a deterrent effect based on the need that I see exists because of Senator Huffine's amendment going on. But I have altered my previous intent listening to Senator West and others, and instead have created a punishment scheme that would make knowingly and intentionally or knowingly openly carrying a handgun when you do not have a license a state jail felony. Members, a state jail felony is punishable by 6 months to 2 years of state jail facility. Again, probation, deferred are all possibilities for punishment, as well as in some situations punishment could be reduced to a misdemeanor. Again, it would require an open carry of a handgun, and this would not be for law-abiding CHL holders, but for those who violated the law and took advantage of this amendment to openly carry. I would move adoption of floor amendment number 12, members, Mr. President.
Senator Estes on the amendment.
Thank you, Mr. President. Thank you, Senator Huffman. Senator Huffman, we had a long debate over the second-degree felony and the state jail felony. I think poses the exact same problem. So with great respect to you, I've moved to table the amendment.
Yes, sir. I would just again request that members think about what we're doing. This is a reasonable solution for punishment. Currently, it's a third-degree felony to carry in a liquor license establishment. It's a Class A misdemeanor to carry a weapon. This would simply be a state jail felony in between those two ranges for those individuals who intentionally or knowingly openly carried and created a threat to our communities. And I move for adoption. I move to vote against the motion to table.
Members, the motion on the floor is to table the amendment from Senator Huffman, and the Secretary will call the roll.
Betancourt, Birdwell, Burton, Campbell, Creighton, Ellis, Eltife, Estes, Frazier, Garcia, Hall, Hancock, Hinojosa, Huffines, Huffman, Colkhorst, Lucio, Menendez, Nelson, Nichols, Perry, Rodriguez, Schwertner, Sulliger, Taylor of Galveston, Taylor Collin, Uresti, Watson,
Give me a no on that instead of an aye.
West, Whitmire, Zaffarini.
Members, there being 21 ayes and 10 nays, the motion to table prevails. That is the last amendment. Senator Estes, you are now recognized on a motion to third reading.
Mr. President, will you yield for a question?
Senator
Happy to yield to my desk mate.
Senator Ellis, you're recognized.
Mr. President and members, my desk mate asked me earlier by voting for Senator Huffines' amendment, was I trying to kill his bill? And I made the comment that I was not trying to kill his bill. It was sincere on my part for totally different reasons from those of Senator Huffines that I would support his amendment. So I just want to let you know that on third reading, I will be voting for your bill. I don't think that many people on this floor have an NRA rating any lower than my rating. And to be honest with you, I have had that low rating, and it has been a badge of honor for 25 years. I don't think I have ever voted on a gun bill. I've made the case earlier that I'm against this bill. The reason that I'm going to vote, Senator, with you on third reading is because I sincerely believe if your bad bill becomes law without the Huffines amendment, there will be more, not less, racial profiling in Texas. And that is why I'm going to vote with you on third reading. I also want to say to Senator Huffines, I don't want my constituents, as I jokingly said earlier, to think I'm drinking the tea. If I am, I hope it's chamomile, because when I wake up tomorrow, I probably won't be with you. But at least tonight, I am. I've heard of strange bedfellows, strange political bedfellows. This has been the strangest bed I have ever seen.
Thank you, Senator, and you've made that strangeness happen.
Senator Taylor, for what purpose?
I just want to get some clarification on what this bill means for our law enforcement from the author, Mr. President.
Yes. Do you yield, Senator?
I yield.
Thank you. As I was talking to Senator Huffines earlier, and I really want to get this on the record because this is important. At least my police department thinks it's important. As I discussed, there are three kinds of stops: the consensual stop, the investigative stop, and the arrest. And this bill, as amended, will continue to allow police officers across the state to make consensual stops. Is that your understanding?
That's my understanding. Yes.
Okay. So consensual stops, after it's amended with Senator Huffines' amendment, which is now on this bill, continue to be legal in the state, right?
Yes.
Okay. Mr. President, if I could ask for this exchange between myself and the author of this bill to be put in the Journal for Legislative Intent.
Members, is there any objection? Hearing none. that will be reduced to the writing in the journal.
Thank you, Mr. President, and thank you, Senator Estes.
Senator Estes, you are recognized on a motion to third reading.
Mr. President, I move passage to third reading, committee substitute, House Bill 910.
Secretary will call the roll.
Bettencourt, Birdwell, Burton, Campbell, Creighton, Ellis, L-Type, Estes, Frazier,
It's like old.
Garcia, Hall, Hancock, Hinojosa, Huffines, Huffman, Colcourse, Lucio, Menendez, Nelson, Nichols, Perry, Rodriguez, Schwertner, Sulliger, Taylor of Galveston, Taylor of Collin,
What do you say? What do you do?
Uresti,
Yes. That's my baby. That's the way that.
Watson, West, Whitmire, Zaffarini,
There being 26 ayes and 5 nays, the bill passes to third reading. Where is Senator Estes? Senator Estes, you are recognized to suspend the constitutional 3-day rule.
Members, thank you so much for this long and lively debate. Thank you so much. And with moving for final passage, we'll get the board up there.
This is not for final passage, this is to suspend the constitutional 3-day rule.
Sorry. Move to suspend the 3-day rule.
Secretary will call the roll.
Mr. President.
Yes, Senator.
A question.
Can we have order?
Did not we just do that?
No, we just moved to third reading. We are now suspending the constitutional 3-day rule.
My apologies. I move to suspend the 3-day rule. Thank you.
Secretary will call the roll.
Bettencourt, Birdwell, Burton, Campbell, Creighton, Ellis, L-Type, Estes, Frazier, Garcia, Hall, Hancock, Hinojosa, Huffines, Huffman, Colcourse, Lucio, Menendez, Nelson, Nichols, Perry, Rodriguez, Schwertner, Sulliger, Taylor of Galveston, Taylor of Collin, Uresti, Watson, West, Whitmire, and Zaffarini.
There being 26 ayes and 5 nays, constitutional 3-day rule is suspended. Chair now lays out third reading final passage. Committee substitute for House Bill 910. The Secretary will read the caption.
Committee substitute House Bill 9. Did you tell me to read it?
Yes, I did.
Committee substitute House Bill 910 relating to the authority of a person who is licensed to carry a handgun to openly carry a holstered handgun.
You're recognized on final passage.
Thank you, Mr. President. Thank you, members. I move final passage. Committee substitute House Bill 910.
Secretary will call the roll.
Bettencourt, Birdwell, Burton, Campbell, Creighton, Ellis, L-Type, Estes, Frazier, Garcia, Hall, Hancock, Hinojosa, Huffines, Huffman, Colcourse, Lucio, Menendez, Nelson, Nichols, Perry, Rodriguez, Schwertner, Sulliger, Taylor of Galveston, Taylor of Collin, Uresti, Watson, West, Whitmire, and Zaffarini.
There being 20 ayes and 11 nays, the bill is finally passed. Congratulations, Senator.
Thank you, Mr. President. Thank you, members.
Members, let me bring you up to date on where we are, because obviously this bill has taken most of our day. We have a lot of bills, and the plan is to work late tonight to continue working. We will not be here in the morning as planned at 8 a.m. We'll have our local calendar, and we have a joint session, and then we will be back Sunday night at 6 p.m. on the floor. We have work to do, and I want to be sure we continue to work through the night to a reasonable time to move as many bills as we can. And once again, members, whether you're for or against whatever was decided, we did it with dignity, we did it with respect on the floor, and the Senate presented themselves well. Thank you.